All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV22 0407, Villalobos versus Maricopa County. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel, is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. We have read the briefs and have discussed this case in conference. So with that, counsel, you may proceed.
May it please the court, my name is David Abney. I'm here appearing today on behalf of the appellants. Once more on a duty case. I just can't escape those. Had one earlier this week, a duty of a business to its invitees, and here we have a somewhat similar duty of a government entity, Maricopa County, to the people that use its roadways. The trial court found that there was no duty here, but there is a duty. It covers the area that Maricopa County controlled, which was the intersection. The odd thing here is, of course, that the direct cause of the danger was the SRP pole that was very badly placed, and then the lack of a stop line or stopping point and improper placement of the stop sign itself. Those are all things within the control of SRP, and maybe as far as SRP's pole goes, maybe to the city, but definitely the city as far as the stop line, and placement of everything there, which created a dangerous condition on that roadway, sure. But it also meant that traffic coming into the Maricopa County jurisdiction from that roadway was dangerous. The trial court seemed to believe that we had not alleged or provided any information that this was a hazardous condition within the area that Maricopa County controlled. But our transportation engineering expert, he opined that the conditions under the city had plainly impeded roadway safety in the area that Maricopa County controlled, that it was an extreme danger at that intersection as a result, and that under the standard of care, it was Maricopa County's duty to do something to make it safe for motorists who were in its jurisdiction. I don't know how I think this is part of the typical problem that we've had over the years where trial courts and sometimes appellate courts conflate duty with the standard of care to fulfill that duty. I don't know precisely, and we won't know until we get it back in trial, precisely what Maricopa County could have done and should have done. Signage comes to mind, putting in a traffic light comes to mind, perhaps putting some pressure on SRP.
But your expert didn't offer any opinion as to anything that Maricopa County should have done.
No, not that I'm aware of. Not that comes to mind right now, but that wasn't the focus of this particular motion for summary judgment. There were some suggestions of things that could have been done. I have to qualify that perhaps the county could have put pressure on the city to
So is there a duty to put pressure on an adjoining landowner?
Well, that's standard of care. The duty is
as I read it, and correct me if I'm misstating anything, I'm always open to correction. So.
Thank you, Your Honor.
As I read the briefs and the trial court's ruling, the county acknowledges there's a duty to maintain its own roads, right? And the allegation is that there were things that could have been done on the city road and by SRP and its property that could have alleviated this accident. And that's kind of standard of care as to that. But is there anything alleged that would was there any allegation that the county had not met its duty as to the road that it controls?
The expert said that Maricopa County had not met its duty of care to make sure that its roadway was safe. There is no duty to
But it was all related to stuff that was could have been done on the other side of the road or
No, things-
beyond the property line?
Things that can be done on Maricopa County's property, for instance.
What were those things?
Well, warning signs, some sort of intersection traffic system, traffic lights, stop, go, so anything that would have helped ease the danger. It was referred to as ultra-hazardous by one of our experts, ultra-hazardous intersection. So there's any number of things that can be done to fulfill the duty of care. But that wasn't the focus of what was going on in the motion for summary judgment.
Well, the motion for summary judgment was on both duty and standard of care, correct? Both issues were raised in the motion for summary judgment.
They were discussed, and there was some evidence of things that could be done on the part of Maricopa County, but that's not where this was decided. This was decided on duty. And in fact, the trial court was very specific, saying, I'm not finding any sort of breach here. We're not worried about breach of any standard of care. What we're worried about here is a duty.
But the parties briefed both issues.
Yes, Your Honor. And evidence was presented from our experts saying that something should have been done, and suggesting, for instance, putting pressure on the city to move things around.
That would be a duty to put pressure.
No, there is no duty to put pressure. There's no duty to warn. There's no duty to do any particular thing. There is a standard of care to make sure that the roadway is reasonably safe for motorists.
But you just said put pressure. That would mean put pressure on the city or SRP to do something.
That's one way to fulfill the duty of care. That's one way of doing it, sure. But the first question, and the one we have to start with, and really where this case fell off the tracks, was, is there a duty owed on behalf of Maricopa County as far as making sure that its intersection was safe? Yes, there is a duty. It has a duty of motorists. Motorists are feeding into the intersection that Maricopa County controls in a highly dangerous way.
Your expert stated that there was a standard care for a public entity's duty to keep its road safe, and it extends to hazards impeding roadway safety, but also, even if the hazard itself is not within the public entity's jurisdiction. What is your best case supporting that proposition?
Rogers versus Ray, 10 Arizona App 119, page 124.
Did you get that citation again?
Rogers versus Ray, RODGERS, Rogers versus Ray, 10 Arizona App 119, point site 124, 1969.
Sorry, the Rogers case didn't find there was a duty. It didn't reach that issue, correct?
Well, Rogers, the point of Rogers, and the importance of Rogers, is that it said that a duty arises even if the dangerous condition was not created by Maricopa County. It was a Maricopa County case, and consisted of something not within its control. So Maricopa County doesn't technically have control of the stop line, stop sign.
But Rogers didn't say there is a duty. It didn't reach that issue. Isn't that a correct reading of that case?
Well, the correct reading of the case is that it is a bit flawed in one point. It was still trapped in that old paradigm of saying that you have a duty to do X, Y, Z. And you don't. Like in a Coburn case, you don't have a duty to put a sign in a particular place or to cut vegetation down or to make sure that your road is straight. Anything, you don't have a duty to do any of those things. What you have is a duty to make sure that your roadway is reasonably safe.
But that doesn't mean
things are standard of care.
But that doesn't mean you're an insurer of the safety of those using the road.
No, of course not.
Does this duty extend to inspecting surrounding jurisdictions to make sure, to look for potentially dangerous conditions?
The duty is to make sure that the roadway is reasonably safe. What do you need to do to fulfill that is a standard of care. Here, our experts and the evidence show that Maricopa County had noticed that it had a dangerous intersection. There were accidents there. There were a number of accidents at a nearby, very similar intersection. There was notice to Maricopa County that it had a big problem, and it didn't do anything about it. But the issue here is there a duty? Yes, there's a duty. But it's not a duty to do a specific thing. When you start talking about specific things, and many of the older cases are phrased that way, you have a duty to put a sign, you have a duty to warn, you have a duty to straighten out an intersection, you have a duty to remove obstructions, all these kinds of things. They're really talking, the subtext is, yes, there's a duty of care, and then this is what you need to do as far as a standard of care in this particular case. And that takes us always back to the particular case that we're in. And in this particular case, what the county needed to do to fulfill its duty of care is up for grabs at this point. And that's something that's going to have to be addressed down at the Superior Court. But the point is, you can't mix the standard of care with the duty of care. You have the duty of care, and then you worry about standard of care.
And so the issue about the briefing, in the briefing below, both duty and standard of care were raised. In terms of standard of care, the argument that was raised or the evidence that was presented by the plaintiffs in support of the finding that there was a breach of the standard of care, the evidence was what? That they should have raised some sort of kerfuffle with the city of Phoenix about the placement of its traffic lights?
As far as standard of care, yeah, work out something with the city of Phoenix or with SRP, or do other things such as warning signs and other, to make that intersection safe. And if anything had been done, as the slightest bit of change, we submit it would have changed the result here. But that is something for the trier of fact. What the standard of care is a trier of fact question. Breach, causation, damages, all those things are standard, are jury questions of fact.
Standard of care is not always for the jury.
Sometimes things are so obvious that you can't, that you'll say, you're sitting there as a judge going, well, there's no reasonable juror on this planet that's going to say that this is a breach of the standard of care. This is not one of those cases. We had a very, very dangerous intersection here, and Maricopa County did nothing about it and knew they had a dangerous intersection. Ultra hazardous was what one of our experts called it. Extreme danger was what another one called it. So we have a bad situation here, and the county's doing nothing. It's saying, oh, we don't have a duty because these problems are off to the side here, even though they knew about them. It's like you have a reservoir on your land, and there's this river that feeds into it, and it floods periodically and fills your reservoir. It breaks and kills people downriver every 10 years, and you don't do anything about your reservoir to make it stronger or better.
But that's a condition on the landowner's property. That's a condition under the landowner's control. What you're saying is that they were required to do something about land that they don't have control over.
No, they're required to do something in reaction to a danger that's off to the side in a street that feeds into their intersection in a highly dangerous way, because people are coming up to that no stop line area, looking, not seeing anything because the pole's in the way, and then they have to make a go, no-go decision, and they go, like this poor woman did, or with her vision blocked, and bam, she gets smashed into by a bus.
And SRP and the city are liable for the things that are under their control. So why should the county be liable for the obstruction created by SRP and the city?
It's not. It's not liable for that. It's liable for the effect. Because the effect makes its intersection dangerous.
Using your reservoir example, is there a case, and not necessarily just reservoirs, but you made me start thinking about this, is there a case in which landowner A is liable for the dangerous condition on landowner B's property?
No, you're not liable for the dangerous condition. You're liable for the effect.
But for the harms caused by the dangerous condition on the
Maybe you live next to a zoo and the animals are constantly escaping and killing people on your property. You need to do something. You need to put up a sign at least saying, watch out, dangerous animals.
Is there a case that says that you are liable because the zoo animals escaped? And you had notice.
I could find a zoo animal case, I bet, or at least a feri naturae
I would
case.
like to see it. Feel free to file a notice of supplemental authority if you can find such a case.
I'll see if I can find.
Well, that case is like the Jensen case, right, where the landowner was liable because the rancher's cattle crossed over onto the highway and someone was killed. That's similar to what you're describing. But there again, the condition, the dangerous condition migrated onto the landowner's property.
Exactly right. The dangerous condition migrated here. The effect of the dangerous condition. In that case, it was cows. Mm-hmm. But in this case, it's cars. And they're coming out where they should be fenced in some way. There should be some sort of control, and there's not. And they get in your land. You have to do something about it to protect motorists because it's your duty. This is your intersection, Maricopa County. You have to do something about it. You can't just sit back and say, it's a problem down there. We know there's a problem and our intersection is hazardous and, we don't have to worry about it because it's not our land where the problem started. But where the problem ends is in Maricopa County's land, and Maricopa County needs to do something about it. That's not a feri naturae example that you gave. That's a feri domesticato problem or something like that, but it's the same sort of thing. You have something that's escaping from your land onto somebody else's land. You have to do something about it or you're going to be liable. It makes sense. Common sense. I'll see if I can find any zoo cases, though, or anything like that.
Sometimes I guess I'm lacking in common sense because I don't see what's sensical about the. I totally get holding SRP in this case and the city liable for the the failures that they've created, but I don't understand why, so if the standard of care requires them, if you've got too much traffic on the road, I totally understand this, the county saying, you should have done X on your road to make it safer, because there's too much traffic on the road, regardless of where it's coming from.
Right.
But that's not this case. All the stuff that I read in your briefing below and above detailed things that the city should have done or SRP should have done.
Right.
And your best argument that I read anyway was that the county should have put pressure via, I think you alleged at some point, maybe they should have sued them.
Sure.
Or yelled at them or browbeat them or something to do more.
Put up a traffic light or signals, warnings.
But it was all that your expert was saying, there should have been a light here on the city side, or the SRP should have done something about the pole.
In the land that Maricopa County controlled, which was basically the intersection, Maricopa County had a duty to make it safe for motorists. There's many ways to fulfill that standard of care, from going after the city SRP, suing the city SRP, putting up warning signs, creating a traffic light. There's many, many things that could be done to fulfill the standard of care. But and of course, Maricopa County didn't create this problem, but it inherited the problem. If you take it a bit to the extreme, every hour on the hour, there's a crash at that intersection because somebody gets confused or has vision blocked by that pole. Hour after hour, people are dying every single day.
Wait, we're talking about the intersection in this case?
At the intersection in our case. Well, don't you think the county would have a duty to do something about it?
Maybe I'm confused, quite possibly. I thought only two cases similar to this had happened at that intersection.
No, there was a dispute about that. I think our people were saying there were 6 cases, and then at a very similar intersection, there were many, many more.
Right, but let's stick to this intersection.
Right.
Didn't your expert say only 2 had been due to the obstruction caused by the SRP pole?
I don't think he limited it just 2. I think it was more than that. There was a dispute about that. The trial judge said only 2, but
You were just speaking hypothetically, if there was hour after hour, one crash every hour.
It would make it clearer what the problem is. The problem is Maricopa County is doing nothing to protect the motorists on its roadway. Sure, they come in an unsafe way because of the stop sign, the stop line, the pole. They get it, but once they get into that intersection, it's Maricopa County who has a duty to protect those motorists. This accident occurred within Maricopa County's jurisdiction. These people within its jurisdiction, its duty was owed to the driver and her and her son in that intersection.
But again, speaking hypothetically, your position would be the same if there had been no prior accidents, right? You would still say that they owe a duty.
Yes, if you could get expert testimony.
Because foreseeability is no longer a factor in the duty analysis. So how does it matter, like Judge Kiley just pointed out, how does it matter whether they had notice of this or not?
Well, you're skipping several steps when we start talking about notice, which I'm not quite sure how it got in the basement level here. What matters is there's a duty to protect motorists in your jurisdiction. Fine, we got that. Whether notice, non-notice really goes to foreseeability, which is a jury question.
Okay, but you raised the hypothetical of what if there's an accident every hour.
Right.
I'm saying, well, let's take it in the opposite direction. What if there had never previously been an accident? You'd still say there was a duty.
Well, yeah, there is still a duty. Absolutely. You owe a duty to people within your jurisdiction, to motorists within your jurisdiction, to make sure your roadway is reasonably safe. There's no question about that. That's the foundation duty. But when you start talking about notice, you're talking about foreseeability. And that is a jury question. If you get a jury in there, and of course they can do anything they want in Arizona, basically, a jury in there and say, well, there's a duty, but we get that. But this wasn't foreseeable.
But if your position is there would be a duty even if there had been no prior accidents, are you saying that the county is an insurer of the safety of motorists on its road?
You're not an insurer. You have a positive, affirmative duty to make sure that your roadway is reasonably safe for travelers. That's your duty.
And the access to your roadways is what you're saying, extending it to also access to the roadways.
Well, it extends to, once people get into your roadway, you owe them a duty. And if you have a situation like that where the danger is being created by somebody else, that doesn't matter so much, does it? What matters is, are they arriving in your jurisdiction in a dangerous way? And the answer is yes. So then you go to the next step, which is for the jury. Well, what's the standard of care require you to do in a terrible situation like this? You've got to do something, one would think, to fulfill your duty of care. I've got 55 seconds.
All right.
52? Yeah.
If we can return it back to 55.
Give them those 3
Thank you,
seconds.
I'm sure Mr. Avenue will make the most out of those 3 seconds.
seconds. There you go.
All right.
Thank you, Your Honor, and good morning. My name is Sean Moore, and I represent Maricopa County in this matter. There was some discussion at the beginning of the appellant's opening remarks about whether this is a duty question or whether this is a breach question. I think it's both. I think that the court can decide in the county's favor on duty or on breach. They are the two legal sides of the same factual coin. And that key fact is that their experts and all the evidence they have presented has not shown any negligently designed or any negligently maintained conditions on the county's road whatsoever. Now, you can characterize that as either, the items that they do complain about are not under the control or the responsibility of the county, or that the county's road was properly maintained and that it met its duty. You can decide either way in this case and still affirm for the county.
So can you speak specifically to the point we've been discussing at the end here, which is whether there's the duty of the county extends to making sure that access to its roads is safe?
Right. So the county has the duty to maintain its own roads in a reasonably safe condition to make sure that there are no dangerous conditions on its roads that can cause a risk of harm. That is its duty. And its duty does not extend to adjoining roads. Our case on duty can be summed down to a very simple premise. You do not have the duty to inspect and maintain your neighbor's property. And if there are dangerous conditions on the neighbor's property that cause risks of harm, it is their responsibility to inspect, maintain, cure those defects. It is not the county's duty to go over to its neighbors, inspect property that has no right to inspect, no reason or right to maintain, and then insist that, material changes be made to another's property when it has no notice to do so, no reason why it would ever be on that property to inspect and maintain. So, does the county have a right to ensure that access is safe? I would say, very broadly speaking, yes. But as a practical matter, that duty only means that the county has to ensure that there are no dangerous conditions on its own property. And as long as it does that, it has met its duty. So,
Mr. Abney's zoo example made me start thinking. So, just hypothetically, there's a zoo next to your intersection, and every day a rhino escapes from that zoo and just rams a car that's waiting at the intersection on county property.
Every single day.
Every single day. It's a very angry rhino. Wouldn't the county have a duty to put up a fence to keep that rhino from crashing into the...
Yes, and the reason in that case is because there would then be a rhinoceros on its property that is causing damage to cars around it. The difference between the zoo analogy, the cow analogy, and what we have here is that the rhinoceros and the cows were on the road that was actually the subject of the case. Here, there is no danger on the county's road. All of the dangerous conditions exist on the city's road. So
to follow up on Mr. Abney's hypothetical, your position would be that even if there was an accident every single hour, that doesn't affect the county's liability because the dangerous condition did not exist on county property.
Correct. I mean, obviously that's a very extreme hypothetical, but as long as there is nothing wrong with the county's property, it does not have the affirmative duty to go to another and say, you need to make changes to your property. Otherwise, the county's liable for not doing that. There's no cases that support that. It expands the concept of duty well beyond what we know and what, all the 58 cases that they've provided. They say, you have the obligation to make sure your road is in a reasonably safe condition, and that road is in a reasonably safe condition. They had multiple experts look at this. This case was litigated for years, and they couldn't come up with a single thing that the county should have done to its road to make it more safe. Their experts did not say a single thing. In fact, their experts specifically said that there was no reason for the county to be alarmed about this danger prior to the accident occurring. Now, their concept of duty is far too simplistic and binary. Basically, they say there either is duty or there isn't duty, and as soon as you say there is duty, you go straight to standard of care and breach.
Where did the accident, and I should know this, and I think I know this, but I'm going to ask you, where did the accident actually occur, or the collision? Where did the bus?
On the county's property.
Okay, so why isn't this then the Rhino hit on the county property? And they should have put up a fence via the form of a stoplight or something to keep that Rhino from coming into the...
So I have multiple responses to that. The first one is that the risk of harm here is not the rhinoceros. The rhinoceros is on the road and it's the risk of harm. The risk of harm here and the dangerous conditions are all those features of the city of Phoenix's road that they talked about. The improperly placed stop sign, the stop bar.
Yeah, this is the zoo. Doesn't have good fencing, so, but now the Rhino, the bus, is on your property.
Right, so vehicles moving down the road in a lawful manner are not dangerous conditions. They're just not. There's nothing the county could have possibly done to prevent this accident from happening, and their experts have openly admitted it. And for that reason, it does not expand in that way. Like, the fact that someone turned out in front of a car, doesn't make a dangerous condition that's the county's property. And the second part of the response that I want to add in here is the mere fact that an accident occurred on the county's property alone, which is all that they have, cannot be the basis for liability. Because if the county's liable merely because an accident occurred on its road, then it is necessarily an insurer of all the drivers on the road. I mean, you cannot be less connected than, oh, the accident happened on my road, and that's it. I mean, that's going to be every single road design case. The government entity is liable simply because the accident happened there.
Well, Mr. Abney's response to that, and I presume, would be that the county should have put up a watch out for rhinos sign on the county property. And so why wouldn't that be sufficient, in this case, an allegation to raise that duty? Hey, look, we've got notice that rhinos are running around here, or school buses. Look out for them.
So let's talk about the duty to warn real quick. I have 4 independent reasons why their duty to warn argument fails. The first one is the argument was waived. They never raised it at the trial level. They only brought it up now, and it's pure attorney argument. Second, there is no evidence that the county had actual or constructive knowledge of the allegedly dangerous condition, so there was no duty to warn. You talked earlier about, how many accidents occurred at this intersection. If you look at the Superior Court's ruling, page 4, footnote 3, the Superior Court specifically found that there were 2 prior accidents at this intersection, and neither of them involved this blocked sight line. So there was absolutely no notice. Now Mr. Abney comes up and he says, well, you don't get into, the duty to warn because it's a breach question and not a duty question, but that's just not correct, because the case law says the duty to warn does not arise until you have actual or constructive knowledge of the dangerous condition. So because there's no actual or constructive knowledge of the dangerous condition, as we've established, then there can be no duty to warn. The third reason is that they have not provided any evidence that the county breached any duty to warn. One would assume that if it was negligent for the county to not put up a sign warning about these left turners, then their multiple experts who looked at the intersection would have said something about that, but they didn't. The record is completely devoid of any evidence saying that the county breached its duty by failing to put up these warning signs. The final point on this is, even if there was notice, and even if the county had not put up the signs, and it should have, there is no legal duty to warn of dangerous conditions on another's property. We provided the case law from that Illinois case saying that a landowner does not have a duty to provide warnings about dangerous conditions that exist on its neighbor's property. I don't think Arizona has directly addressed that issue, but the simple fact of the matter is property owners have a duty to maintain and inspect and take care of their own property. They do not have a duty to maintain, inspect, and take care of another person's property. And to even inch into that territory is a significant expansion of duty that has no precedent whatsoever.
At the trial court level, the issue was briefed on both duty and standard of care breach.
Correct. So,
and what was the evidence presented by on the issue of breach? What did the experts say could or should have been done?
The experts did not point out a single thing that the county should have done to improve its roadway that would have prevented the accident. Not one thing. Now,
Mr. Abney just told us that they said a sign or a stoplight. That's not true?
I do not recall seeing that in the record, Your Honor. If it is there, I apologize, but I do not recall seeing that anywhere. The idea that there was this duty to warn is something that has come
A
up on
stoplight
appeal.
wouldn't necessarily be a duty to warn.
I mean, a stoplight wouldn't be a duty to warn, that's correct. But, I mean, they were talking about, put up this warning sign, stoplight. I mean, they theorize that it's something that may have, my recollection of the record is it's something they theorize may have helped, but they said that the county had no idea, or had no reason to be alarmed about this risk prior to the accident. So they found that there's no reason that the county would have known, even assuming everything in their favor, that the county would have known that this risk existed. So going back to Judge Kiley's point about, did we talk about breach at the trial level, I would say, so I've thought of their breach argument essentially boils down to, well, you found duty, and breach is a jury question, so you have to just kick it straight back to the trial court. I personally refer to this as their pay no attention to the man behind the curtain argument, because they're trying to distract you from the fact that they have absolutely no evidence that the county did anything wrong. And that's the bottom line. You can't ignore the elephant in the room, which is they have no evidence the county did anything wrong, and that provides you more than adequate basis to decide in the county's favor on breach. Now, just because the trial court decided on duty alone doesn't mean you can't decide on breach. The case law is pretty clear that you can affirm for any reason in the record, and the parties fully briefed the issue below, so there's no reason to not decide on that issue.
So if we assume then that there is a duty, maybe not perfectly defined, but there is a duty involved here, we could affirm the trial court?
Correct.
On what basis?
Because they have not presented any evidence that the county was in control of any instrumentality that could have fixed this accident, or prevented the accident from occurring.
So there's no showing of a violation of the standard of care for the county?
Correct.
And in summary judgment, the burden is on the plaintiff when it's been raised to put forward some evidence.
Correct.
That could be admissible that would show that there was a breach of the duty.
Correct. And they have that affirmative duty to put forward the evidence. Not only did they not put forward the evidence, but their experts, when asked, what else is wrong with this intersection that could have prevented it, they said nothing. Like they actively affirmed that there was nothing the county could have done to prevent the accident. But going back to that question of duty that you just referred to, Judge Morris, as I was starting to say a little bit earlier, their duty.
I forgot what question did I.
Oh, you said, assume that there's a duty.
Oh.
Yeah. So, yeah, apologies. So their conception of duty is too binary. They either say, yes, there's a duty, no, there's not a duty. But duty is a more complicated question than that. It's not just, do I owe any duty, then we go straight to breach, do not pass go, do not collect $200. It's a more nuanced question than that. The question is not just, does the defendant owe any duty at all to the plaintiff? The question is rather, did the defendant have a duty to ensure the reasonable safety of the mechanism that is allegedly causing the injury? It's more specific than that. So here's an illustration. As I stand here today, I owe Mr. Abney a general duty of care, right? If I drop my briefcase on his foot and he's injured as a result, he can then sue me for dropping the briefcase. But just because I owe him a general duty of care doesn't mean I owe him a duty to ensure that the chair he's currently sitting in is well maintained. If the chair breaks and he injures himself, he cannot then turn around and sue me for it because I did not have a duty to maintain the chair. The court did, or whatever jural entity maintains the chair. And so just the general existence of a duty does not answer the duty question.
It's the presiding judge's responsibility.
It's the presiding. Well, then he could sue Judge Cruz for the injury stemming from the chair. But the duty question isn't just answered, is there a duty, yes, no. It asks whether you have a duty to maintain or ensure the safety of whatever mechanism it is that caused the injury. And in this case, what they're saying is, here are the specific road design features that we believe caused the injury, and the county does not have the duty to maintain any of them. They are exactly like the chair in this illustration. You have to have a duty over the relevant mechanisms in order to go to the breach question, and that simply does not exist here. All right. I just want to address a couple of things that Mr. Abney said in his remarks. The first is that he said that the trial court made a simple no duty ruling. That's not necessary. That's not an accurate representation of what the trial court found. The trial court's ruling was much more nuanced than just that. Judge Viola specifically found that the plaintiffs had not come forward with anything to show that the county had a duty to inspect, maintain, or improve those road design features which are the subject of the plaintiff's case. And because of that, the county could be dismissed because of duty. It wasn't strictly that, oh, the county doesn't have any duty whatsoever. It's that it doesn't have a duty that's relevant to this lawsuit. The next thing that I want to bring up is he says, Mr. Abney said, the county is not liable for the dangerous conditions, it's liable for the effect. And I want to concentrate on that a little bit because the effect that he's talking about is the accident itself. He's saying that even though the county is not responsible for the mechanisms that allegedly caused the accident, it's still liable for the accident merely because the accident happened on the county's road. And that is specifically asking this court to find that the Maricopa County is an insurer of everyone on the road because the mere fact that the accident occurred can be a basis for liability. And that's just simply not the case in the law. And so it's not liable for the effect. You have to be liable for the causes. Tort law, as we explained, kind of briefly in our answering brief, is concentrated on assigning liability to those who controlled the causes of the injury because they were in the position to prevent the injury from occurring. In this case, that's the city of Phoenix and maybe SRP, not the county, because the county was not in control of any of the instrumentalities that caused the accident, even by their own allegations. And Mr. Abney admitted it himself. This is a direct quote. Maricopa County did not create this problem. You can affirm right there on that statement alone, because as long as Maricopa County didn't create the problem, tort law doesn't try to assign liability to it. And so I think that's really the end of the discussion. There was also, in the briefing, some talk about the court's ruling on the motion to bifurcate. I'm not going to spend any time on that unless the court has any questions on that issue. And unless you have anything else, I will yield the remainder of my time. Thank you.
Thank you.
Mr. Abney, did your expert affirm that there was nothing the county could have done to prevent the accident?
No, and I think if you look at Index of Record 66, page 16, paragraphs 96 to 98, you get a good cross-section of what our transportation expert was saying. In particular, paragraph 98, he said that under the standard of care for the situation, Maricopa County was obligated to make reasonable efforts to correct and ameliorate the intersectional defect, which could easily have done and should have done long before this. We're just talking about Maricopa County property. We're not talking about the area where the stop line was.
But did he say anything specific, or did he just say in general terms they should have done, quote, something?
He said something at that point, and at other points our experts said they should have done things like put pressure on the city and SRP to change things around, or to do other things like, I believe, like signage and traffic lights.
Can you give me that record site again?
That one, the one I just gave you?
Yes.
Index of Record 66, page 16, paragraphs 96 to 98, and in particular 98 is very helpful. I've burned through my time, so if there's no further questions.
All right, thank you.
Thank you.
Council, we thank you for your briefing and your arguments. This matter is now taken under advisement, and we will issue a written ruling in due course. We're at recess.